Hi, welcome back. We've made it to week 5, a little over halfway done. This week we'll be spending our lecture talking about constitutional law. This will come out of Wong's chapter 6. You may be asking, how in the world does constitutional law apply to sport and the sport industry? We'll spend a good portion of our lecture today talking about that. Then next week, we'll also address some ways that constitutional law additionally applies to sport in the industry. I want us to think about, though, that constitutional rights and amendments most often apply to sport and when it involves issues regarding freedom of speech and religion, due process, equal protection, and the right from unreasonable search and seizures. These rights and protections are often found in what we would consider the First, Fourth, Fifth, and 14th Amendments. So we will be addressing some of these. Obviously, constitutional law are that which we could apply to all 50 states. And so there are some broad concepts, and we'll be thinking about how we can narrow those and apply them specifically to sport and the sport industry. Because sometimes it's difficult to wrap our brains around ways that sport might apply to our constitutional rights, I'm going to give us a couple scenarios and or examples. We'll be working our way through these, and that'll help us understand the concepts and terms later in the lecture. Our first scenario is this. Athletes on an intercollegiate soccer team decide to wear black warm-up shirts to protest police brutality in the U.S. This has resulted in angry fans at several games, as fans feel it is not appropriate for collegiate athletes to protest such issues. This actually does indeed address a constitutional right. We'll look more at that later. Our second example of constitutional rights applying to sport is this one. Coach Smith has noticed that his star player Sally has not been herself. She has lacked her typical motivation and competitive spirit. At today's practice, Coach Smith noticed that Sally has red eyes and smells of smoke. During warm-ups, Coach Smith went to Sally's locker and searched through her belongings. Believe it or not, this also is a constitutional right. We'll be talking more about this in the coming slides. Now that we have a couple examples in our mind, let's dig a little deeper on how we consider how the Constitution applies to sport. As we've seen earlier, we have individual scenarios. So how indeed can we think about the law applying to those individual scenarios? First of all, we have to recognize that the constitutional law involves the application of federal, state, and local entities, and whether those entities and actions of those entities violates one or more terms of the U.S. Constitution. And in both of our previous scenarios, we indeed see violation of an individual's U.S. constitutional rights. We'll talk in a little bit about then what is a state entity, because that's really important in our application and understanding here. I also need us to recognize that purely private entities are generally not subject to constitutional claims. This is really important. Constitutional law does not apply to professional sports. Why? They are private entities. Let me make that clear. Pro sports are parties of the collective bargaining agreement. Players' unions agree to the collective bargaining agreement, and therefore certain individual rights are relinquished. Because of all of this, professional sport leagues are not state actors. They are indeed private entities. Therefore, constitutional law does not apply in those instances. Let me give you an example. More recently, we have seen protests done by a number of professional athletes, first being namely Colin Kaepernick. In this instance, if Colin Kaepernick is prohibited from kneeling for the national anthem, that is not indeed in violation of his constitutional right. Why? Because he's a member of the National Football League. The National Football League has a collective bargaining agreement with its players, and the players' union agrees to the terms of that collective bargaining agreement. Therefore, the National Football League is not a state actor. And because of that, Colin Kaepernick could not, in his instance, determine that his constitutional rights were being violated here. Okay, let's say then what it looks like for state action or to be a state actor. Okay, we have learned that constitutional law does not apply to our professional sports. So who does it apply to when we consider the world of sport? It applies to state actors. To successfully prove a constitutional claim, we must first show that state action exists. So who are state actors? State actors are those who act in furtherance of their position as employees of government agencies. Again, that may seem a little broad. Okay, how does that apply to sports? Public school teachers are government agencies. IRS employees, county government employees, staff at the DMV, and athletic directors at state-run universities are indeed state actors. We're going to see later in the lecture some case law that helps us understand why these agencies, individuals, are indeed state actors. In keeping with several of our previous lectures, hopefully we're starting to recognize that when we're addressing case law and legal issues, there's often these lists of things a plaintiff must prove, in order to show a violation. Okay, as we've already established, in order for their constitutional claim to be made, plaintiffs must show that a state action exists. We'll talk more about that in addition. We saw some of that already prior. Second, the plaintiff must prove that the claim is not frivolous and that the claim concerns a right of enough importance to be heard in federal court. Please make this connection. This is not a state issue, although we have to have a state action. These issues are heard at the federal level because indeed we're talking about constitutional law. Please make sure we keep those concepts separate. Okay, at the end of this, we have to recognize in order for it to be a constitutional law claim, the plaintiff must prove our three things: that state action exists, and that first must be done. Then we have to be able to show that the claim is not frivolous and that it concerns a right of enough importance to be heard in federal court. Okay, let's begin to work a little more in detail through our previous list of those things a plaintiff must prove in order to have a constitutional claim. State action. We're beating this over the head, but it's super important under constitutional law. State action is an action taken directly by the local, state, or federal government. It also includes public schools and state institutions. This is really important. Therefore, when sport is in a public school setting or in a federally or government setting and or state institutions, which are many of our universities, almost all of our universities, we'll get there in just a little bit, these indeed are state actors. Therefore, when we begin to think about then who might have a constitutional claim, it would be athletes that are playing in for a local government agency. It's athletes in a public school. It's athletes or others involved in college athletics. Those indeed have the courts, have repeatedly ruled those indeed are state actors. It can be fairly simple to see, as stated in our previous slide, that there are definitely sport organizations that are state entities. They receive and or act as branches of the government. But what about those organizations that might be private? And what happens when they're accused of being a state actor? There are two ways that we are going to think about determining if state action exists when private organizations are accused of being a state actor. Two theories to apply in this instance: the public function theory and the entanglement theory. Public function theory helps us think about or address things that seem private that can be public when no counterparts exist or provide a similar service. We can also think, does the organization provide services that have no counterparts in the private sector? Organization or things that seem private can be considered public when no counterparts provide that similar service. Okay, so what's an example of this? If only one fitness facility existed to serve an entire community, that facility could be considered a state actor. Also, in the world of our high school sports, Private entities might be things like high school athletic associations. In the state of Texas, this is the UIL. No other state high school association exists in the state of Texas, and therefore the UIL, because of the public function theory, is likely to be deemed a state actor. Okay, second theory, the entanglement theory. How much money, influence does the government provide to this private organization? It helps answer the question, how much do the two, this private entity and the government, act as one? Oftentimes this, as I've already indicated, can come through or be recognized by modes of money and influence that the government provides in that organization. If we have been able to determine that a state action does exist, what's next? Our questions then become, how important is the right being violated? How important is the reason for violating that law? While these questions, don't have perfect answers, we have some guidelines to get us towards answering them. How can we answer our previous questions? That is, how important is the right being violated and how important is the reason for violating it? This is a consideration of fundamental versus non-fundamental rights. Unfortunately, there is no list that tells us exactly what is a fundamental and what is not a fundamental right. However, the courts and our legal system have given us some parameters. We'll address those next. So, how important is that right being violated? Through a series of decisions, our Supreme Court has determined that some rights are absolutely fundamental. Therefore, the importance of those rights is of the highest importance. They've given us three: free speech, free from warrantless searches, and free from self-incrimination. Those are absolutely fundamental rights. Therefore, if those are being in question, how important are those rights being violated? They are absolutely considered a fundamental right. If we've determined this then, that a violated right is considered to be fundamental, a much stricter level of scrutiny will be applied. To that second question, how important is the reason for violating that fundamental right? That's what we call strict scrutiny. The violation is necessary to accomplish a compelling state interest. There is only one way, and it's absolutely necessary. What does that mean? One of the ways that a defense can prove that the violation was appropriate is through this notion of strict scrutiny. What if it's a non-fundamental right? If we have been able to determine that the right being violated is not free speech, it is not freedom from warrantless searches, and it is not freedom from self-incrimination, therefore it's considered a non-fundamental right. If it's a non-fundamental right, then the level of scrutiny is much lower. That is, go back to those questions. That level of scrutiny is applied to how important is the reason for violating it. The scrutiny applied to that then is much less. It's called mild scrutiny. This determines that the violation is rationally related to a legitimate state interest. Fundamental rights receive strict scrutiny. State actors must prove that of the strictest scrutiny as to the reason why they indeed might have violated this constitutional right. When it's a non-fundamental right, that scrutiny is much less. It's mild. Therefore, a state actor must only show that that non-fundamental right was rationally related to the legitimate state interest. Let's work our way through some very important sport associations and consider whether or not these are state actors. First, let's think about our Olympic and national governing bodies. These are indeed not state actors because of their worldwide emphasis, and most of the decisions for the Olympics and national governing bodies go on beyond aspects of the U.S. Therefore, these are not considered to be under our federal jurisdiction. As I've already previously discussed, professional sport leagues are private entities and therefore are not state actors. Why? Professional athletes negotiate with professional organizations and leagues via their collective bargaining agreement. Therefore, they are not state actors. Making our way down across athletic associations, next in line comes intercollegiate athletics. We'll think about this twofold. First of all is the NCAA. The NCAA is not a state actor, and this is a bit of a teaser or a spoiler. You're going to be addressing this in one of your case briefs of Tarkanian versus the NCAA. You will learn, and I'm not going to spoil it for you, why indeed Tarkanian was unable to determine that the NCAA is a state actor. However, it's important to note that college conferences, the makeup of the conference and or whether it's private or a public institution determines whether or not that's a state actor. High school athletic associations, where do they fall under state action? They indeed are state actors. You'll see this in your second case brief for this week of Brentwood Academy versus TSSAA. That's the Tennessee Schools Athletic Association. That case will help you understand and recognize why high school associations are indeed state actors, but collegiate associations, as in the case, as we'll see with Tarkanian versus the NCAA, are not state actors. There are two specific principles of law that impact amateur athletic associations, and we need to consider them to help us understand when a court will review or address issues regarding constitutional law and amateur athletic associations. First is this notion of limited judicial review. That is, courts are not in the interest of reviewing every legislative decision made by amateur athletic associations. Instead, they will defer to the organization's decisions for the most part. Our court system will only intervene when the following three things are present or considered: that the amateur athletic association's actions did indeed violate constitutional rights, that the amateur athletic association violated their own procedures and or rights, and when basic notions of fairness have been violated, we can consider those to be arbitrary and or unreasonable. Also, it's important to note then that a plaintiff must have standing when bringing a claim of a constitutional claim against an amateur athletic association. And how does a plaintiff prove standing? The plaintiff must be able to show that the action in question did or potentially would cause injury, and that injury does not have to be physical harm. The interest in question must be of a constitutional nature, and the plaintiff bringing the constitutional claim must be the one whose interest was infringed upon. That is, an outside party is not able to bring this claim for the plaintiff. Because of the nature of amateur athletics, there are a couple of important additional principles we have to consider that the courts might rule or use to apply to amateur athletics. Because of the nature of amateur athletics, let's think about this. For example, if we're considering high school athletics, maybe even lower school athletics, those seasons and time frames are rather short. Let's just take, for example, a high school lacrosse player. This individual potentially may have a constitutional claim of some type against their high school or a high school athletic association. In these instances, it's fairly common for our courts to provide what is injunctive relief. So what is injunctive relief? It's what is called fair, non-discriminating form of judgment to redress a wrong or an injury. There are several actions that fall under injunctive relief, 3 of them specifically. There's a temporary restraining order, and this gives relief for a maximum of 10 days. Let's go back to our example of our high school lacrosse player. Let's say that high school lacrosse player is no longer or has had their constitutional rights violated, and they claim that their high school is not allowing them to compete on the lacrosse team, and therefore those constitutional rights are violated. The court might indeed impose this temporary restraining order that would give relief for 10 days. So that means the lacrosse athlete would be able to compete for the next 10 days. There's also what's called a preliminary injunction. This is granted prior to a full hearing and both sides give imposition on the case. This preserves the status quo until all sides of the case can be heard. As we know, our legal and court system is not always super speedy. And therefore, because of the nature of amateur athletics, it could be that a preliminary injunction is put in place so that the student athlete in question could continue to play while this time, and then the courts will hear. Lastly, there can be a permanent injunction. That is, the full court case has to be heard. It allows no action until full court case has been heard. This also then would halt the current situation and therefore return things to as they were, and that then would require that the entire case has been heard until a permanent or primary action has been made. Why does the court offer injunctive relief oftentimes in these instances? Because of the unique nature of amateur athletics and the time frames typically imposed. This is a way to address and not take away oftentimes what we would consider the right of the athlete and or organization. Now that we have some bearing about constitutional claims, I want to spend the remaining of our lecture addressing the First Amendment. Next week, we'll be addressing several other constitutional laws as we think about due process. But for the sake of this week's lecture, we're going to attend to our First Amendment rights. What are our First Amendment rights? I have them stated here. Our First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for a redress of grievances. Whew, okay, don't worry, I'm going to make some sense of that in just a minute. One of the ways that we have repeatedly seen First Amendment play out, specifically as it applies to sport, is freedom of religion. I want us to think about this. The application of the First Amendment to sport includes religious issues. This is predominantly seen in public school-based prayer, freedom of expression, and freedom of choices. There's two clauses to consider under religious issues. Our first is the Establishment Clause, and this prohibits the establishment of a church by the state as well as the endorsement or preference of religion and coercion of religious practice. That would fall under something such as a private school requiring a public school to require students to subscribe to a certain school-based prayer or religion or religious practices. On the other side then is what's called the Free Exercise Clause. This prevents government or its agencies from interfering with one's religious beliefs. Therefore, this gives the right of people on campus to assemble under what they would deem to be their religious beliefs and exercise that freedom. Our U.S. Supreme Court utilizes 3 tests to determine whether religious practices that are challenged under the First Amendment are indeed unconstitutional. We have 2 of those tests here, and our 3rd test will be addressed in our next slide. First is the Lemon test. This is called the Lemon test because it derived out of Lemon versus Kurtzman. Under this test, there's a 3-part concept to determine whether a government or religious practice is unconstitutional. First, that religious practice or government practice is unconstitutional if it lacks a secular purpose. Second, that government or religious practice is unconstitutional if its primary effect either advances or inhibits religion. Third, that government or religious practice is unconstitutional if it excessively tangles government with religion. On that 3rd component, think separation of church and state. Next is the coercion test. This test determines or helps us examine whether a religious practice coerces or pressures groups of people to participate. Think back to our previous slide and example regarding public institutions requiring that students abide by or practice a certain prayer and or religion. Therefore, if these tests are met, we can potentially see that the practice might indeed be unconstitutional. We'll move now to our third test. The third test utilized to consider whether government and or religious practices under the First Amendment are unconstitutional is the endorsement test. This test is used to consider whether the government and or religious endorses a particular religion or disapproves of another one. Think about it this way. Is a religion favored, preferred, or promoted over other beliefs? Therefore, if it is, that behavior and or practice indeed might be unconstitutional under our First Amendment rights. Here are two examples of First Amendment case law that I want to work through just briefly to give us some context and key application of First Amendment case law. Our first case is Bethel School District versus Frazier. Mr. Frazier was the school president, and over the loudspeaker while giving announcements, he poked fun of teachers and administrators. He was subsequently pulled out of school and suspended. Mr. Frazier went on to file suit under First Amendment free speech. That is, Mr. Frazier believed it was his freedom of speech to poke fun of teachers and administrators, particularly over the loudspeaker during announcements. The courts, however, thought differently. They ruled that disruption is not the only cause for restricting free speech. In addition, the courts ruled that there must be a balance maintained between the freedom to express unpopular and or controversial viewpoints with the school's responsibility to teach socially appropriate behavior. This case is often applied, particularly in school settings, as well as in athletic settings. We can also think about this particularly as it applies today to social media. Our second case is Tinker v. Des Moines. This was in 1969, and we can think about what was going on particularly in 1969, so roughly around the Vietnam era. Tinker, a student at the school, started a movement that encouraged students to wear black armbands in protest of the Vietnam War. Administrators warned students that if they wore the armbands, they would be suspended. Some students were indeed suspended, and Tinker went on to sue under his First Amendment freedom of speech rights. The courts ultimately ruled that students do not give up their constitutional rights upon entering the school doors. Therefore, Tinker did indeed have a right to wear that black armband to school. Furthermore, the courts ruled that school administrators had to obtain authority but could not restrict when the conduct will materially or substantially disrupt but can only restrict, when the conduct will be materially or substantially disruptive to the educational process. That's key to make there. If then that process would have been highly disruptive to education, potentially then they might have been able to restrict. However, we have to think about three questions then. Does this expression interfere with the educational function? Does the expression interfere with the rights of other students or faculty? And in the instance of Tinker, by simply wearing a black armband, the courts ruled that this didn't. You'll see the application of these two cases often in discussion around First Amendment law, even as we consider it applying to sport. Okay, here we are at the end of week 5. This has gotten us through our discussion on what are constitutional claims and how we are able to make constitutional claims, as well as some First Amendment rights. We're moving on next week to talk about due process. And under due process, we will also be addressing a number of other constitutional laws that fall under due process. Have a great week, and I'll plan on seeing you next week.